Hi, sir. Can you tell me your name, please?
Michael Fable?
Mr. Fable? Okay, I'm going to call your case in just a minute, so I'm going to put you on hold, but please remain on the line, okay?
Absolutely.
Thank you. Okay, Mr. Blumberg, are you able to hear me okay?
Yeah, right through the trees, I can see it, Judge.
Glad that you have power at your office.
We did as of Saturday, I think. No, yes, yeah, Saturday. So I was in here trying to catch up on a whole week of work. So, but my clients, Mr. Beland is here, and I see his wife is there as well.
Okay, great. So we'll go on the record then. This is Beland versus Beland, case number 2419895. As Mr. Blumberg indicated, he's present with his client. I do see Miss Beland connected as well. We're on the record today for a status conference in this case. Mr. Blumberg, can you tell me from your side of things where we're at?
Yeah, Judge, I think we've concluded a referee hearing in regard to custody. And while we're still in the objection period, I think we have an agreement on custody and parenting time and support. The parties have agreed on the sale of the marital home, which is really the only significant asset of this marriage. So I think we probably can have a judgment ready within the next 30 days to be entered.
Okay, Miss Beland, were you able to hear what Mr. Blumberg said?
Yes, sorry. My attorney Matt isn't on.
Oh, were you represented? I'm sorry, I'm showing you
Yeah,
as
Matt.
unrepresented. Okay, hold on one second. I thought that was
Okay.
an attorney signing in on a different case, so
No.
I'm sorry.
Okay.
Okay, counsel, I'm sorry, I didn't see you listed as counsel of record in this case. Could you just put on your appearance, please, on behalf of Ms. Beelan? Mr. Butcher, are you appearing on the Beelan case? I don't think you can hear me.
Okay.
Hold on one second here. I'm gonna send him a message.
Your Honor, would you like me to try to text him?
He saw my message because he kind of held up a finger saying just a minute.
Okay.
So I think he may be trying to reconnect or adjust the settings in some way.
Thank you.
Mr. Butcher, are you able to hear us now?
Yeah, I got on my phone. I had my child at my computer over the weekend. I think he might have screwed with the settings. My apologies.
Okay, can you put your appearance on in this case, please?
Yes, may it please the court, Attorney Matthew Boucher appearing on behalf of Brittany Beland, who is appearing via Zoom as well.
Okay, and I started the hearing. I didn't see that you had filed an appearance, so I didn't realize she was represented at this point. But Mr. Boucher, we did start the discussion on the status of the case. Mr. Blumberg indicated that he believed that there were agreements in place and that parties would be ready to enter a judgment within the next 30 days or so. What's your position on the status?
I believe that's an accurate representation. I believe the parties have a marital home that is or has been listed. I believe that remains the only lingering issue, but I do believe that Mr. Blumberg's representation is accurate.
Okay, so the court will set this for a final hearing to take proofs and enter the judgment. We'll do that by Zoom as we're doing today. Mr. Boucher, and you may have filed an appearance. You know, we were closed all last week, obviously due to the weather. But to the extent that you haven't, if you could file that so that we can make sure that you're included on the next notice of hearing for that final hearing, okay?
Yeah, sure. I do see that it was sent out early last week, so it may be in the works, but I will follow up and ensure that that is received.
Okay, thank you. Mr. Blumberg, anything else that we need to address on this file today?
I don't believe so, Judge. Thank you.
Mr. Boucher?
No, Your Honor. Thank you.
Okay. And then Mr. Blumberg, I know you're on the 9:15, but I do have one other in between that, so I'm just going to put you in the waiting room until that hearing.
Great. Thank you.
All parties are free to disconnect on this file.
Thank you.
Thank you.
Getting the house listed. Okay, all right.
Ma'am, can you tell me your name, please?
Kara Fable.
Okay, thank you. 1 second. Okay, we have Mr. Fable connected now. We'll go on the record. This is Fable versus Fable. Case number 2419899. The record should reflect both parties are present by Zoom video for this hearing today, which is a status conference, and I have it as a potential final hearing. Mr. Fable, you're the plaintiff in this case. Are there any matters regarding the division of assets or debts between the two of you that need to be addressed by the court, or have you been able to reach agreements on those things?
No, we reached agreement on everything.
Okay. Ms. Fable, would you agree with that?
Agree.
Okay. So what we need to have happen now to finalize the divorce is there's a final form called a judgment of divorce. Mr. Fable, as the plaintiff, usually it would be you that would fill out that form and get that to the court. Do you have a copy of that? Did you get your forms online for the divorce, or where did you get your forms?
I got my forms from the court office, and I've been trying to turn it back in. I know it's been a little late, but office has been closed the last week, so.
Right, okay, so do you have that filled out and ready to go?
Yes, sir.
Okay, and did you get did you get that approved by friend of the court as well?
Oh, I've been trying to,
Oh.
like I said, I turned it in a little bit late, so I haven't had a chance to actually see anybody.
Okay, all right, and you're correct. I mean, we were, because of the ice storm, we were closed all last week, so that may be part of the delay. So I'm gonna go ahead and set this for another final hearing. And Mr. Fable, it's just important that if you can follow through with that, have those documents turned into the court before that next hearing, and we can finalize the divorce at that time. Do you have any questions, Mr. Fable?
No, sir.
Ms. Fable, do you have any questions at all?
Nope.
Okay, thank you. That's all for this hearing today, and the court will send out notice of the date and time of that final hearing in about 30 days. You're both free to disconnect.
Thank you, sir.
Thank you.
Okay, looks like we have all the parties in council connected. We'll go on the record in Odin versus Odin. This is file number 2419861. If I could have both council put your appearances on, starting with plaintiff.
Good morning again, Judge. Elliot Blumberg on behalf of the plaintiff Nancy Odrin, who is appearing, I think, through Zoom from a different location.
Good morning, Your Honor. Cassandra Suter on behalf of defendant Brian Odrin, who is appearing via Zoom today.
Okay. Thank you. This is set for a status conference today. It looks like the parties did participate in mediation, and my file reflects that there was an agreement reached. Mr. Blumberg, can you tell me the status from your standpoint?
Yes, Judge. I think the parties have agreed on all issues, including the most recent child support issue. So we've prepared a consent judgment that is in the process of being circulated. If the court would indulge us, maybe we can take the proofs today, preserve them until the judgment gets sent to you.
Thank you. Ms. Suter, do you have any objection to taking proofs today?
I do not.
Okay, so Ms. Odrin and Mr. Odrin, and Ms. Odrin, I'm going to need you to unmute if you can. Thank you. I'm going to ask both of you to raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can both lower your hands. Mr. Blumberg, if you'd like to proceed with testimony from your client.
Thank you. Nancy, can you state your full name for the record, please?
Nancy Jean Odrin.
And you are the plaintiff in this action for divorce. Is that correct?
Correct.
You filed a complaint for divorce, and in it you had alleged that you were married to Brian Lee Odrin in Roseville, Michigan on March 20th, 1998. Is that correct?
Yes.
You also alleged that that ceremony was performed by an individual who was authorized to perform marriages. Is that correct?
Yes.
Your maiden name was Nancy Jean Polmarchuk. Is that correct?
Yes.
And are you asking the court to have that restored to you or to remain Odrin?
Remain Odrin.
Okay. In your complaint, you alleged that you had been a resident of the state of Michigan for at least 180 days immediately preceding the filing of your complaint. Is that true?
Yes.
You further alleged you've been a resident of Otsego County for at least 10 days immediately preceding the filing of your complaint. Is that also true?
Yes.
There are still two minor children born in this marriage. Is that correct?
Yes.
That would be Abigail and Mylan Odrin. Is that also correct?
Miles.
I'm sorry, Miles. I can't read my own typing. Thank you. And you and Mr. Odrin have come to an agreement as to both custody and parenting time in this matter. Is that correct?
Yes.
You understand that you are going to be sharing joint legal custody of your two children
Yes.
and that you will have primary physical custody of the kids. Is that correct?
Yes.
You alleged in your complaint that you are not currently pregnant. Is that true?
True.
You allege that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that the true of the time you filed this action?
Yes.
And is that true today?
Yes.
There is no likelihood that you and Mr. Odrin would get back together living as husband and wife, is there?
No.
Now, you and Mr. Odrin and your counsels have participated in mediation in this matter, which resulted in a property settlement of all the assets and liabilities. Is that correct?
Yes.
Do you understand that you are not going to be receiving spousal support, nor is Mr. Odrin, and that neither one of you can come back at a later date petitioning the court for spousal support? Do you understand that?
Yes.
In terms of the division of the marital estate, the agreement that the two of you have reached, you believe that to be both fair and equitable.
Yes.
And in terms of the division of the financial obligations, the debts, do you believe the division to be both fair and equitable?
Yes.
And as to the custody, parenting time, and support issues as it relates to your children, do you believe that to be in their best interest?
Yes.
Are you asking the court to adopt this agreement and dissolve this marriage by entering a judgment of divorce?
Yes.
Judge, I don't believe I have any other questions.
Thank you. Ms. Suter, did you have any questions for Ms. Odrin?
I do not.
Okay, did you want to take any testimony from your client today?
Just quickly, yes.
Okay, please proceed.
Brian, could you please state your full name for the record?
Brian Lee Odrin.
You were present at the mediation via Zoom February 13th, 2025, correct?
Yes.
And you understand the mediation agreement that was entered into with your Sheffalo and opposing counsel and your wife?
Yes.
And you understand the custody and parenting time provisions, and you believe that they are in the best interest of your minor children?
Yes.
You understand that you will not be receiving spousal support and it is forever barred?
Yes.
You believe that the property and financial aspects that were agreed upon are fair and equitable?
Yes.
And you would like the judgment to be entered today?
Yes.
Okay, thank you.
Mr. Blumberg, did you have any questions for Mr. Odrin?
No, Judge, I do not. Thank you.
Thank you. The court has heard the testimony of both parties today. The court finds that the statutory grounds for divorce have been met by that testimony. The court will grant the divorce, and the court will not set any further hearings in this case. The court will look for that judgment and will sign that once it's been presented. Mr. Blumberg, do you think that that can happen within the next 30 days?
I do, Judge. Yes.
Ms. Suter, any reason from your side why that could be accomplished?
No, there should be no reason that can't be accomplished.
Okay, great. Thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you.
Thank you.
Miss Anderson, are you able to hear me okay?
I am, Your Honor. Can you hear me?
I can, thank you. So this was a hearing set, you're signing in on Lee versus Lee, is that correct?
Yes, Your Honor.
Okay. And that's file number 2419864. Do you have your client with you there?
I do not. We just got our phones and internet back over the weekend. I've tried to contact her and she may not have those back, so I've not been in contact, unfortunately.
Yeah, so I don't see Mr. Lee either. Mr. Blumberg was on the record earlier this morning, so I don't know if he's having connection issues. So we have one of two options. I can either put you on hold and we can wait to see if anybody does connect, or I can just reset this. What's your preference?
Well, Your Honor, this was our originally scheduled pro-con. Clearly, in this case, we are nowhere near a pro-con date. Our continuation of hearings with you isn't until the end of May, and we don't have front of the court evidentiary hearing until July. So I don't think this particular hearing needs to be reset other than a date well beyond July for a pro-con. So I'm fine with calling this what it is, unnecessary, and we're just not there yet, so.
Sure, and that makes sense based on my knowledge of the case as well. So what I'm going to do is just have the record reflect for purposes of today's status conference that further hearings will be continued until those that are scheduled for May. I'll note that no other parties were present, although I'm not going to place any kind of fault on any party for not being present today due to the weather complications that we've had. And to the extent that Mr. Lumber would want to object to what we're doing today, I would give him an opportunity to do that. And I will put that into a status conference order. Anything else I can address for your side today?
No, thank you, Your Honor.
Okay, thank you, and you're free to disconnect.
Thank you.
Okay, Ms. Shackelford, are you able to hear me okay?
Yes, sir.
Thank you. And Mr. Sanchez is signing in here, so if you can just hold on for just a minute.
Okay.
Just while we're waiting for that, is Isaac there? Is he available?
Yeah, he's here.
Yes, okay.
I have terrible service at this point. My goodness.
Mr. Sanchez, are you able to hear me?
I can, sir, but barely. My service is terrible currently.
Right. No, I totally understand. Did you want to reschedule this hearing, understanding, and Ms. Shackelford, I don't know if you're aware, but here in Gaylord in northern Michigan, we had a terrible ice storm
Yeah,
last
my
week.
daughter sent me the pictures.
Yeah, the court was closed for a whole week, which is highly unusual, and many people still do not have power. Mr. Sanchez, did you want to continue this hearing until you have a better connection?
If possible, could we reschedule if that's okay? And Miss Shackelford, I'll be in contact with her within the next few minutes if that's okay. Just to converse
Yeah.
with her briefly about the situation, if that's all right.
Do you have any objection to that, Ms. Shackelford?
No, sir.
Okay, all right. Again, given the recent weather and state of emergency here in Otsego County, I think that's reasonable. So the court will reset this for another hearing. I'll send out notice of the date and time of that to all parties. And you're both free to disconnect. Thank you.
Okay, thanks.
Our next hearing is set for 10:15, so we'll be in recess until that time. Ma'am, can you tell me your name, please?
My name is Jennifer Wirchus.
Okay, I've got one hearing before yours, so I'm just gonna put you on hold for just a minute, okay?
Okay. Thank you.
Thank you. Okay, looks like we have all the parties connected. We'll go on the record, excuse me, in Casper versus Casper. This is file number 2419733. If I can have counsel put your appearances on, starting with plaintiff.
Yes, good morning. Jennifer Zalesnik appearing with it on behalf of the plaintiff, Rebecca Casper. She is actually present via Zoom.
Judge Elliot Blumberg on behalf of Mr. Casper is appearing via Zoom from my office.
Thank you. This is set for a status conference today. I am in receipt of what appears to be a proposed judgment of divorce. Ms. Zalesnik, is it your intent to take proofs from your client and enter that judgment today?
Yes, Your Honor.
Okay. Mr. Blumberg, are you prepared to do that as well?
Yes, Judge, I think everybody has executed the proposed judgment at this point.
Okay, thank you. Ms. Casper, and if you can point the camera at Mr. Casper.
Sure.
Mr. and Ms. Casper, I'm going to ask both of you to raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can both lower your hands. And Ms. Zalesnik, if you'd like to proceed with taking testimony from your client.
Yes, thank you. Rebecca, can you just please state your name for the record and spell your last name?
Rebecca Ann Casper, Kasper.
And at the time that you filed the complaint for divorce, had you been a resident of Otsego County for at least 10 days?
Yes.
And a resident of the state of Michigan for at least 180 consecutive days or 6 months?
Yes.
When filling out the complaint for divorce, you set forth certain allegations. Were the allegations true then?
Yes.
And are they true today?
Yes.
And has there been a breakdown of the marriage relationship?
Yes.
And have the objects of matrimony been destroyed?
Yes.
And is there any reasonable likelihood that the marriage can be preserved?
No.
Okay. So if Judge Mertz did not grant the judgment of divorce that he has there with him today, would you go back to living with Matthew as husband and wife?
No.
Okay. Is it true that there were 3 children born during your marriage?
Yes.
Okay. And just can you say the names? You don't have to give the full names and the ages.
Landon, 14, Kyler, 7, Colton, 2.
And are you currently pregnant?
No.
And is it true that you and Mr. Casper have been able to work out a custody and parenting time arrangement?
Correct.
Do you believe that that custody and parenting time arrangement is in your children's best interests?
Yes.
Okay. There's also child support awarded in this case. Do you think that child support order is in your children's best interests?
Yes.
And also you reached an agreement regarding the division of your marital assets and debts. Is that what you understand?
Yes.
And do you believe that that is a fair and equitable division of your marital estate?
Yes.
Okay. You've had an opportunity to review the judgment of divorce. Is that correct?
Correct.
And the judgment of divorce memorializes the agreements between you and Mr. Casper. Is that correct?
Yes.
And are you asking for the court to order or enter the judgment of divorce and the uniform child support order today?
Yes.
Okay. You understand that you could have gone to trial and you could have done better or worse, but are you asking the court to enter the judgment of divorce?
Yes, please.
And do you have any questions for either me, myself, or the judge?
No.
Okay. Are you satisfied with the efforts of your attorney?
Yes.
Okay. I have nothing further, Judge.
Mr. Blumberg, did you have any questions for Ms. Casper?
Ms. Casper, you understand that the property settlement in this matter was a result of mediation. Is that correct?
Correct.
And you and your attorney and Mr. Casper and I participated in that. Is that correct?
Correct.
Now, as to spousal support, you are not seeking nor you are being awarded spousal support in this case. Is that correct?
Correct.
Okay, you understand that neither you nor Mr. Casper can come back at a later date and petition the court for spousal support.
Correct.
And again, just to reaffirm what you've already said, as it relates to the custody and parenting time provisions, you believe that to be in your children's best interest?
Correct.
And as to the property division and division of debts, you believe that to be both fair and equitable?
Correct.
Thank you. I have nothing further, Judge.
Thank you. Mr. Blumberg, did you have any testimony that you wanted to take of your client?
Just briefly, if we could. Now, Matthew,
Okay.
you've heard everything that your wife has testified to today. Do you believe that to be an accurate statement as the agreement of the parties?
Yes.
And as to the custody and parenting time, you believe that to be in the best interest of your children?
Yes.
And as to the division of assets, you believe them to be fair and equitable?
Yes.
You're asking the court to ultimately sign this judgment of divorce?
Yes, I am.
Thank you. I have nothing further, Judge.
Ms. Selesnik, any questions of Mr. Casper?
No, but I have one, I forgot to ask Miss Casper if I could, please.
Sure.
Okay, you're not asking to return to your maiden surname, is that correct, Miss Casper?
No.
Okay.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony and parties today. I did have a chance to review the proposed judgment as well as the proposed child support addendum to that judgment. The court finds that it's generally equitable. It contains all the provisions required by statute. The court will grant the divorce, and I'm signing that judgment with today's date. Ms. Lesnick, anything further we need to address for your side today?
No. Nothing.
Mr. Blumberg?
No, Judge, thank you.
Okay, thank you. That's all for today. Mr. Blumberg, I know you've got the 10:30. I do have one in between that, so I'm just going to put you in the waiting room again.
Okay, thank you.
Thank you, Judge.
Thank you.
Okay, Ms. Wirtjes, are you able to hear me okay?
Yes, sir.
Okay, this is Wirtjes versus Wirtjes, file number 2419926. The record should reflect that Ms. Wirtjes is present today by video, Zoom video. This is the date and time set for entry of a default judgment of divorce. Is that how you wanted to proceed today, ma'am?
Yes, sir.
Okay. The record should reflect that this hearing was set for 10:15. Mr. Wirtjes has not appeared today, either by video or in person. The record should also reflect that he was properly served with the summons and complaint, that he did not file any type of answer, that a default was entered, and that he was provided with notice of the date and time of today's hearing, which again was at 10:15. It's now 10:27 by my clock. Ms. Wirtjes, I've got some questions that I need to ask you. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Wirtjes, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage could be preserved. Was that true when you signed that complaint?
Yes, sir.
Does that remain true today?
Yes, sir.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
No, sir.
under the judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes, sir.
All right, and the judgment indicates that you've already divided up any debts or assets of the marriage. Is that correct?
Yes, that's correct.
And you don't own any real estate or real property together?
No.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Wirches. The court has reviewed the judgment of divorce, finds that it's equitable, it contains all the provisions required by statute. The court will grant the divorce, and I've signed that judgment with today's date. And you are asking to have your last name changed, is that correct?
I was, but I'm getting married again in a few months, so it doesn't really, it's not I probably won't actually go do the paperwork to do it until I get remarried.
Okay, so do you want me to cross that paragraph 16?
Yeah, that's fine. You can go ahead and cross that off.
Okay, so I'm gonna cross off paragraph 16, and so your name will remain the same. However, your divorce is final as of today. Do you have any questions at all?
No, sir.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Okay, we'll go on the record in Vander Kirchov versus Vander Kirchov. This is file number 2419800. If I could have both counsel put your appearances on, please.
Reagan Richards, P 87197, appearing on behalf of plaintiff Haley Vander Kirchov, who is appearing via Zoom.
Good morning, Judge Elliott Blumberg, on behalf of the defendant who's appearing via Zoom from my office.
All right, thank you. This is set as a status conference today relating to property issues. I know there are still some ongoing proceedings in front of the court in terms of child support and so forth, but as to division of debts and assets, Ms. Richards, can you tell me kind of where things are at in regards to that?
From my understanding, the biggest assets to divide are the house and the cars. I'm waiting on an appraisal. I believe one has been scheduled, if not done. Mr. Vander Kirchov is still living in the house. So we're just waiting for that.
Okay, do you have any suggestions for scheduling going forward or what you'd like to see for a scheduling order?
I believe another status conference. I think we should be able to resolve everything once. I'm just waiting on information at this point.
Okay, Mr. Blumberg?
Judge, the house has been appraised. We have an appraisal. I can share that with counsel if she wishes. But yeah, there are just property related and debts that need to be resolved. I'm not, we've already gone through mediation once in regard to custody. I'm not adverse to either the parties meeting themselves or with a mediator to try to resolve the remaining issues.
Okay, I think what I'll do is I'm going to refer this to community mediation then. I'll allow 60 days for community mediation if the parties want to, give it a shot before you actually meet with the mediator. And if there's an agreement reached, then certainly the court would set it for a date after that and excuse the parties for participating in mediation. But I think referral at this point is a good idea. And then I'll set this for another status conference at about that 60-day mark. Ms. Richards, any objection to that going forward?
No, Your Honor, thank you.
Mr. Blumberg?
Oh, that's fine, Judge. Thanks.
Ms. Richards, any other dates that I can address for your side this morning?
No, Your Honor.
Mr. Blumberg?
No, Judge. And again, Ms. Richards, if you wish to have a copy of the appraisal, we'll make it available. I don't know if you hired somebody else already to do it or not.
No, I was waiting on the appraisal you had scheduled.
Okay.
Okay, so the court will again refer it out to community mediation. We'll set this for a status conference at about 60 days. I'll send notice of the date and time of that to counsel. And all parties are free to disconnect on this file.
Thank you.
Thank you, Your Honor.
Okay, looks like we have counsel connected. We'll go on the record in Sheridan versus Sheridan. This is file number 2419880. If I could have counsel put your appearances on, starting with plaintiff.
I believe that's us. Good morning again, Judge Elliott Blumberg on behalf of Ms. Sheridan, the plaintiff in this matter.
Good morning, Your Honor. Brooke Robinson. I believe actually Doug is the plaintiff in this matter. So I am representing Doug Sheridan, the plaintiff.
Okay, thank you. We're on the record here today. There was previously a status quo order entered by the court. Ms. Robinson, you've objected to that. I did have a chance to review your written submission. Is there anything you wanted to say in support of that here today?
No, Your Honor, everything is in order in our submission.
Okay, Mr. Blumberg.
Judge, just simply put, there's been some payments made towards a partial property settlement in this matter, unilaterally determined by Mr. Sheridan. My client's unemployed. She has some disabilities, and so we're just simply asking the court to continue to require Mr. Sheridan to make those payments that he has historically made. Again, these are just normal day-to-day expenditures that my client shouldn't have to dissipate her property settlement to maintain the marital home. So, you know, we're working towards a resolution in this case, so I don't know how much longer this order will even be needed. But in the meantime, she's dissipating the part that's very small portion of her property settlement just to maintain the marital home. He doesn't reside there.
Okay. Mr. Robinson, anything you wanted to say in response?
I will say that she has access to her own separate funds. Neither party needs to dissipate any part of the marital property in order for her to maintain her own living expenses right now. My client also is retired and living on a fixed income. Part of that being a retirement settlement that is subject to division. We are not disputing that at all. We simply ask that the defendant in this matter be expected to pay her own expenses out of her own separate funds so that neither party has to dissipate property.
Judge, I don't mean to interrupt again, but she has no separate funds. She's unemployed. She's an elderly woman with disabilities. We're just asking the court to require him to maintain those expenses that he has historically paid.
Okay. All right. Where are we at in terms of, has this case gone to mediation yet, Ms. Robinson?
Yes, Your Honor, it has gone to mediation. We suspended mediation temporarily so that we could take another look at things. We did have a mediation scheduled, unbeknownst to either party, to revisit this. And I believe that the parties are close to an agreement that we can do this either face-to-face on our own or re-engaging mediation again.
Judge, just to be clear, the mediation clerk or the person at community mediation failed to send notices to the attorney. So while it was scheduled, nobody knew about it.
Okay. All right. Do we have a date out there for it now?
I believe it's being rescheduled. We just have to look at this. All happened within the last week, so we have to look at some schedules right now.
Okay. All right. So I looking at the objection, I also had a chance to just review the initial motion that resulted in the status quo order, which is a fairly, common order that the court enters in divorce matters, particularly where there are children involved. I think what I have at this point, in order for the court to grant the objection, I think what I would really need to have here is some evidentiary support for the claims made. And in this type of motion, it's difficult for the court to make a decision because it really does need to be based on evidence of income, of what funds each party has, and I just don't have that in front of me. And we didn't have this scheduled for an evidentiary hearing today. So to the extent, Ms. Robinson, that your client wants to seek to have the order terminated, I would request that you contact my office, set this for a 1-hour evidentiary hearing, and submit some documentation as to your client's financial situation. Mr. Blumberg, you'd have an opportunity to respond to that and submit financial information on the part of your client. But at this point, I don't have an evidentiary basis to discontinue the status quo order. So the court's going to deny the objection without prejudice, subject to an evidentiary hearing. The order will remain in place until that time. Obviously, if the parties are able to settle this prior to that date, then it's a moot issue. And if not, then the court would have an evidentiary basis to either discontinue the order or continue it. So that's the court's ruling today. Ms. Robinson, if you can prepare an order that just reflects what the court has decided today and submit that under the 7-day rule or with the stipulation as to form from Mr. Blumberg. Ms. Robinson, anything else I can address for your side today?
No, Your Honor, thank you.
Mr. Blumberg?
No, Judge, thank you very much.
Okay, thank you. That's all for this hearing, and both sides are free to disconnect on this file.
Judges, the
I was already clicking the button when he started talking, so I'm sure if it's important, Mr. Blumberg will give us a call. Court's next hearing is set for 11:30. We'll be in recess until that time.
If we can't figure out.
Judge, what do we have on at 11:30?
The Emmett County case that I have by assignment, so
That was gonna be my backup plan.
Okay, all right, sounds good. Thank you.
okay, thanks.
Yep.
Okay, Mr. Ingleson, are you able to hear me okay?
Yes, I can, Your Honor.
Okay. So this is Troac versus Van Wormer, case number 241085553, Emmett County file. I'm sitting on this case by assignment. And I think there may have been some confusion regarding today's hearing, just after talking to my assistant. That we have Mr. Troac now has counsel.
Right.
And we have a hearing date set for their motion to set aside the default on April 25th. And so I don't know that Mr. O'Keefe, who is Mr. Troac's counsel, got notice of the hearing today, because I don't see him appearing, and
Right. Okay.
I would expect counsel to appear. So my suggestion, unless there's some other record that you'd like to make, Mr. Ingleson, is that we just continue this to that hearing on April 25th. The court will rule on the motion to set aside the default, and then we'll go forward from there.
All right. And the time on the 25th, I don't have my file in front of me. Is it on there handy for you or not?
I do not have that.
All right, I'll get it myself, Your Honor. So yeah, that's fine. Waiting till the 25th works fine.
Okay. All
Very
right, so
good.
that's all. Thank you, and you're free to disconnect at this time.
All right, thanks. Take care. Bye.
Okay, that concludes the court's morning docket. The court will be in recess until